Good morning, Your Honor. Thank you very much for allowing me to appear. My name is Laura Handman. I'm from Davis Wright Tremaine, and I am joined today by my colleagues Greg Thomas and Carol LaCicero from Thomas LaCicero. And we represent the petitioner book defendants in this case, Hachette Book Group, which published the hardcover and softcover of The Infiltrator, the Penguin Random House, which published the audiobook of The Infiltrator in 2015 and in 2016, Robert Mazur, the author, and KYC Solutions, his personal corporation. Allison Steele is here to represent the movie defendants, and will have 8 minutes for my opening, reserving 3 minutes for rebuttal, and Ms. Steele will take 7 minutes for her opening and reserving 2 minutes for rebuttal. This is a case where the circuit court, in denying the motion to
Excuse me, when
Sure. 8 and 3?
7 and 2.
Correct. I
Thank
think
you.
it comes to 20. The circuit court, in denying the motion to dismiss, departed from the essential requirements of Section 770.01, which requires a notice before suit for libel for publications or broadcasts in newspapers, periodicals, or other medium. And this is a part of the protection that Florida offers for the First Amendment, and is a jurisdictional condition of suit. In this case, the issue...
If I may, Ms. Hanson, let me see if I could zero in.
Sure, please.
Because there's two separate matters for us to consider. The actual, what I call substantive matter, whether or not your client falls within the statute, like other medium, and then the other issue is the cert standard. So let's focus first on the first one.
Okay.
I know you've taken the position, and the brief lays it out beautifully. In fact,
Thank
I got to
you.
commend both sides, did an excellent job laying all this out. I know you're taking the position that your client ought to be as part of other mediums. Our court, back in 1984, and I want you to zero in on Bridges versus Williamson, aren't we bound by that decision that basically says that that statute only applies to media defendants and not to non-media defendants? Help me out with that.
Sure. I think what has become the touchstone to define who is a media defendant is, are they engaged in the dissemination of information or commentary about matters of public interest? So, for example, the individual who posted on an internet web message board was not deemed to be someone engaged in essence the business of dissemination of information. Here we have what I would say book publishers are profoundly in the business of publishing and disseminating information. Here, a nonfiction book about Operation Sea Chase, one of the most consequential investigations conducted to end the money laundering by the Medellín Cartel. It resulted in 85 indictments. It is a matter of extreme public interest, and that's what this is about. That is dissemination of information. If a website that provides information about hair restoration products is deemed other medium, I would suggest clearly a book publisher is, and clearly the author of the book is as well. In the Mancini, here the author, as you know, is a true American hero, served our country for 3 decades in some of the most dangerous positions, went undercover as a money launderer, and resulted in this incredible takedown of...
And how do you, because one of the analysis, and it goes back to the Ross case, and this is this is what's really governing everything, is the Ross laid out exactly what you've indicated. But one of the things that has still progressed on with the interpretation of that statute by our sister courts in the state of Florida is, again, you're dealing with how sometimes the immediacy, that some of the analysis that goes like, well, in this in these blogs or in these newspapers, because they're so quick in trying to provide this dissemination of news or things that would be very important to people, that you need to have that built-in protection. In a book, the other side argues, well, once the book is published, it's out there. You don't have that immediacy that you could retract, or that would make it fall within the others. How do you respond to it?
Well, I'm very glad you asked that question, because book publishing, much like the rest of the industry, has changed and advanced. So you only have to look at what happened here. The original book was published in 2009. 7 years went by, no complaint from the plaintiff. He was, named in the book, no complaint. On the eve of the launch of the movie and the publication of a paperback edition timed with the launch of the movie, we get a letter May 3rd, 2016, saying Mr. Javier Ospina is not involved in the cartel, not involved with drugs, and not involved with a vigilante group. And what happens is the book publisher and the movie company take what the plaintiff identified, prior counsel for the plaintiff identified as the curative measures. Remove the name Baraya from the book, from the ebook, from the audiobook, removed any reference to his family lineage. He was the grandson of the former president of Colombia, and removed that, was able to do all that based on having received that notice. What happens then is why we are here. They publish the 2016 book thinking they have addressed the concerns, and the next thing they hear is a lawsuit in September of 2016. No notice that the 2016 edition, which does not contain the reference to Baraya, the family name, is at all a concern. That is against what this 770.01 pre-action notice requirement is supposed to do. It's supposed to give the publishers notice in case they can take further action, like remove it from the ebook, remove it from the audiobook, exactly what they did here.
Can I ask you a more narrow statutory question? Should I not read other media in the context of broadcast, periodical, other media? So other media should be something like the two categories that precede it.
Well, as you know, the internet has become, since the time in '76 when the statute was expanded deliberately to encompass more kinds of media, more kinds of platforms.
Newspapers are now online. Magazines are now online.
But, for example, in the Commons case, and a very, I think, very informative decision there, reviewing all the history, they ultimately found that a blogger who had a blog, public intellectual, was covered by the 770. And as I mentioned, so was the hair product website. So it's hardly limited to newspapers or broadcasts. It's meant to expand who is producing, disseminating information, and therefore needs this warning to be able to take corrective measure, to be able to avoid punitive damages. And there's no reason, when they take as broad a term as other medium, they deliberately pick that to be able to encompass future developments or other ways in which important information gets disseminated. And books are surely one of those ways.
You're a little bit over your 8 minutes.
Oh, I'm sorry.
Yes. We'll give you rebuttal time.
Thank you.
Thank you. Ms. Steele?
Thank you, Your Honor. May it please the Court, I'm Allison Steele, and I represent a list of 9 entities who had something to do with producing, directing, writing, or acting in the movie that is the subject of this lawsuit. There are 2 issues, I believe, that are raised in the briefs in the case. And the first, with respect to my clients, is very easy to dispose of. First is, the respondent plaintiff argues that he complied with Section 70.01 of the Florida statutes. And I submit to the court that strictly within the four corners of the complaint actually pleads that he didn't. Paragraph 72, he sent a letter to the movie defendants without saying or showing any exhibit which defendants would those be and what did it say. On May 3rd, 2016. That was more than 2 months before the movie premiered. That's also pleaded. Paragraph 49. The motion picture Infiltrator premiered in Tampa on July 13, 2016. And so, if 770.01 applies, it would have been impossible for him to have specified the statements therein. In other words, within the publication in question,
I'm
that were
curious,
false and defamatory.
was that raised below, was that argued below in a motion at the hearing on the motion to dismiss?
Yes, Your Honor.
Because I know the primary focus was on that, but that was also mentioned as well?
Yes, Your Honor. Yes, it was.
Okay.
I'll move on from that point, and I want to go to the central question. I believe, Judge LaRose, you asked the definition of other media. The actual statutory language is other medium. When the statute was initially enacted, it covered newspapers. When it was amended in 1976, it added broadcast, and it added, instead of a list of other types of media, the word other medium. It makes it distinctly different from a statute like Montana's, where Montana is a retraction statute, actually has a list. Newspapers, magazines, periodicals, radio, or television. Florida's doesn't have that. And certainly in 1976, someone in the world might have known about the internet, but I don't think we did. And it certainly was not in use.
Let me direct you to one of the issues that concerns me.
Mm-hmm.
I know you're taking the position that a movie ought to, and if you look at the case law, Ross and so forth, the key is, it's like, and I know you indicate this is based on a true story, but isn't a movie sometimes is geared more for entertainment than actual, I mean, this was not a documentary, correct?
That is correct, Your Honor.
All right, so how do you answer to the question that because it's not a documentary, even though it's based on a true story, there's some liberties are already thrown in because of the entertainment value that will take you out of that statute?
When we look at how the courts, including this court, have looked at that word medium in the context of 770.01, the courts have made a distinction between media defendants and non-media defendants. You know, we can pretty well understand why somebody towing a banner is non-media. We can pretty much understand why someone just talking on a CB radio is non-media. But people who are engaged in the regular production and distribution of information or commentary of public concern or interest are engaging in core First Amendment activity. And that's one of the points that the court in Ross versus Gore made when it was just simply talking about 770.01 in connection with, well, why should a newspaper get special protection? It's the people engaged in core First Amendment activity. And I would submit to Your Honor that that can include fictionalizations of events that actually happened. Not everything has to be a documentary. There's the case Tyne, which dealt with the movie Perfect Storm, which was a fictionalized account. And many of the relatives of the men on that boat were very unhappy about how their relatives were depicted. But one of the key points that the Florida Supreme Court made is that that is core First Amendment activity. To be able to bring before the public a new or different view or unearth new facts in order to cause people to reflect, to think, to cause them to experience the range of human existence.
And if we agree with your position, you think that's consistent with bridges, or do we need to recede from bridges?
Bridges says that the statute doesn't apply simply to random people who ended up being quoted in a newspaper story. The case does say the language of the statute is limited to newspapers, periodicals, and other media, not non-media or private individuals. I believe that the court has to bring bridges into the current century.
Which then leads me to and I didn't get a chance to ask, but perhaps in rebuttal, the cert standard. The cert standard is extraordinary high. So if we go with your both positions, how can we say that the trial court deviated from the essential requirements of law, that the judge blew it all together when you're dealing with a statute that's broad, that his or her interpretation of the statute, we may disagree with it, but that may be okay. And so that's a struggle in terms of the high cert standard.
I agree with Your Honor. Because this statute in particular is a jurisdictional prerequisite to bringing suit, it has been found in a number of cases to be a cert-worthy and proper subject for the court to pronounce on, for the appellate court to pronounce on in the first instance. The first internet case that came along, the internet is not mentioned in the statute, and yet there was a cert petition and there was a quashal because the appellate court determined this does fit within the definition of this particular statute. So I recognize that it's somewhat unusual to bring probably what is in Florida a case of first impression on cert. However, I believe to make the statute work and be workable, the court does need to update what it has done in previous cases.
So if we come to that, are we then conflicting with our case law that basically said that if there's an issue that's debatable and there's no case law on point, there's really not a clearly principled, an established principle of law for the court to depart from, and then really cert should not be granted?
But this is an established principle of law that newspapers, broadcasters, and other medium practitioners are protected by 770.01. That is an established principle of law. And so the question before the court is, do movie distributors and directors, screenplay writers, and the guy who acted in the movie, are they entitled to that level of First Amendment protection as described in Ross versus Gore? And I would ask the court to consider.
Ms. Steele, you're going to have to wrap it up, please.
Pardon?
You're going to have to wrap it up.
All right. I would ask the court to consider the different varieties of people engaging in extremely important First Amendment activity. Netflix, Amazon, podcasts, documentaries, and dramatizations that were not envisioned, I think, when this court decided the Bridges case. And what it would do here would be to deprive all of those makers of First Amendment activities of the protections of this extremely important statute. Thank you, Your Honor.
Thank you.
Thank you.
Mr. Pollenberg?
May it please the court. Good morning. John Pollenberg on behalf of the respondent, Francisco Javier Ospina Baraya. I may use the terms that I defined in the briefs to refer to the parties and the matters involved here. In preparing for this presentation today, it occurred to me that this media, non-media defendant issue that you were talking with counsel about is central to the whole decision, as it were. And therefore, what I wanted to submit to the court is that the distinction between media and non-media defendants really has to do with the distinction between, as counsel said, First Amendment rights and the right to a free press. What the statute deals with is the right to a free press. And that's an important distinction to consider here. Because while the right to a free press needs the right to exercise free speech, not all free speech is an exercise of a free press.
I tell you, one of the struggles, it's a fascinating case and fascinating issue. One of the struggles that I have, and if I could impose this hypothetical for you, we see this all the time where there's a series of articles published in the newspapers. True stories, just a whole sequence. Day one, you've got this issue, an expose on all children's. The second day, another expose, continue. So you have all these published articles. Then somebody decides, and under that scenario, obviously the statute would apply for the protection. Then somebody thinks, I'm going to take all of these articles and put them in a book. These are all the same thing. And then you have them in a book. Are you suggesting, while they're entitled to that protection, but because now it's been put together or codified in a book, it's the same language, same everything, oops, that doesn't apply? Help me out with that.
Well, Chapter 770 deals with single publication. So if all you're doing is compiling former newspaper articles and then putting them together in a compilation and not making any change to the content, I would submit that whatever the original publication was would be governing there.
But that's in a book. But it's a book.
But Your Honor, I would submit to you that it's not the same, and it's not the same in the movie either. And to say that each publication where the author or the publisher of the statement makes a separate independent publication anew would be subject to having the 5-day if that applies. But I'm sorry.
No. Because the statute itself, regrettably, there's no definition what other medium is. And whenever you have a term, and I know there's case I'll say that if a statute does not have the definition of, does not include a definition, you look at other statutes for in peri materia. So help me out with one thing. If you look at 770.01, we all know what it says. But what's interesting, if you look at, when they talk about choice of venue, 770.05, it does deal with limitation of choice of venue. And in that one, it indicates, quote, no person shall have more than one choice of venue for damages for libel or slander. And then it says, upon any single publication, exhibition, utterance, newspaper, and it mentions book, magazine, and even motion picture. So my question to you, if we're going to look at it in peri materia, doesn't that address a motion picture, a book, and couldn't a conclusion would be that's also included in that broad definition of medium?
Well, there's actually two, I believe, Your Honor, there's two issues that's comparison of the statutes raises. First, the statute talks specifically about venue for a claim for damages. Okay? It doesn't talk about the condition preceding to bringing a suit that 770.01 talks about. Okay? So what you're then suggesting is that that publication, which includes movies and books, would then be something that relates to 770.01 for definition purposes. And I would submit, as Judge LaRose mentioned, that if you take that definition of other media and expand it to include, in this case, books or movies, then what happens is the statute essentially reads publication in any media, including newspapers and periodicals, right? That's essentially what that argument would mean. In which case, all publications, you don't have to worry about it. All publications, as a matter of bright line rule, would be subject to the pre-suit notification. But as I mentioned in my opening remark, that the context that we're dealing with here is that there's a distinction between what 770.01 and 770.02 deals with, which is the rights that the state of Florida has determined are important for a free press to be able to quickly disseminate information and news through news and broadcast versus the right to free speech, which has its limitations, and defamation is one of those limitations. So when you talk about the idea that the pre-suit notification under Florida Statute 770-01 would have to be read in its context, as Ross suggested prior to the amendment, as Bridges did post-amendment, I remind you, and as the cases, even the cases, Commons v. Van Voorhees, that the petitioners rely on heavily, which goes through almost as a treatise would, all the cases interpreting 770-01 to get to the current day in a case that was decided by Judge Seitz, in which it was a performer posting press release on his website that was determined non-media defendant. That's in the Southern District of Florida. Those cases are all cited.
Remind me, is there any staff commentary related to the amending of the statute that added this language?
I haven't seen it, Your Honor. I will submit to the court that for it to consider the idea of legislative analysis or legislative history, first you'd have to determine that the statute's vague or ambiguous, and then you would be able to look behind what the statute actually says, and using the canons of construction to determine exactly what the statute means. That would be your first determination, that this clause, other medium, is vague and ambiguous, and then you would then have to look at legislative history, which I have not done that analysis, because neither party has raised the issue that is vague or ambiguous in the court below or in the appellate briefs.
And the term other medium, we all agree, that's very broad. Would you agree with that?
Absolutely.
Okay, and because it's very broad, or maybe it's done on purpose very broad, why not to, as the other side has indicated, it's so broad that perhaps the legislature thought to encompass and to include all that, especially when you're dealing with Ross as to the free dissemination of important issues. And I know what you've indicated about the analysis between the free press versus the free speech, but wouldn't their argument is, well, this book, it's a true story. It has very information that would qualify under that. The book, the movie, the same thing. How do you respond to that?
Well, first, I dispute the idea that it's a true story. That's the whole basis we're in the lawsuit. But putting that issue aside, Your Honor, the idea other medium being construed broadly would violate one of the canons of construction, which says that when a general term follows specific terms, that the general term is bounded by the specific terms that precede it, which I think is the point that Judge LaRose was making when he asked the petitioners about the issues related to interpreting what that term other medium. And as you raised, the Bridges case, the Ross case, and all the cases subsequent to it talk about that the statute means it only applies to media defendants. And when a statute, and media defendants, by the way, isn't just the dissemination of news and information. The cases talk about it's the dissemination of news and information through news and broadcasting. That's what the cases have interpreted that media defendant term to mean. In other words, the press. And that's the point I'm trying to make. The statute has never been applied in the way that the petitioners ask the statute to be applied here. And to do so requires us to rewrite the statute so that it covers all medium, not just newspapers, periodicals, and other medium that's like newspapers and periodicals, i.e. the press. There's no real argument here that books that are published are actually not the press. And I don't think there's any argument that movies are not the press. Now maybe back in the day when you would go to the movie theater to see newsreels, maybe that would be something that would qualify as a press-type event, because it would be that type of dissemination. But as Your Honor mentioned to the movie defendant petitioners, this book is based on truth, but it's not true. My client dies in the book. My client, I assure you, is still alive. So the book, while it depicts him in a way that we believe is factually wrong, the book is a work of fiction, and therefore is not the press by definition, as you recognized. And so I wanted to switch to another point that you raised as far as the search standard is concerned. The idea that Florida Statute 77001 is subject to a petition for writ of certiorari is because pre-suit notifications, like in the med malpractice area, are deemed to be, if you don't get the notice, it's a prejudice to your rights, and therefore you meet that standard. But as Your Honor pointed out, the idea that the trial court made a substantial departure from existing law, the court is wrestling with this idea now. That's not a substantial. You might disagree with what the trial court did, but this isn't the time to do it. And I would point out that assuming, even if you assume, for the sake of this argument, that 77001 applies to these petitioners, they have argued that they received a letter and they responded to it, trying to mitigate damage. And 77001 is designed to work with 77002, which requires that you get notice of a retraction, and then you do something to remedy it. Now, the reason it doesn't apply to these petitioners is because 77002 talks about you have to identify the article or broadcast. Well, we all know that the book is not an article, and the movie is not a broadcast. So 77002, by its own definition, doesn't really apply to the parties in this case. And I would further say that if you bought a book or you saw a movie, now, you know, I will submit to you, my kids have a tendency to see some movies more than once, but not many people read a book more than once. If you retract the statements in a book or publication, the people who read the book don't see the retraction.
How do you respond to the fact that in the history of this case, 2006, there was a request for retraction? They were able to accomplish that.
Oh, and you mean in 2016?
Correct.
Well,
Yeah.
so let's talk about that, because that's a great point. The retraction occurred for anybody who's going to read it going forward. Now, I don't think the retraction was effective to reduce the harm that my client sustained. But for anybody who read the book, or anyone who saw the movie, or heard the interviews about people who were describing the movie, that bell was rung. And the people who saw those things, my client's harmed. And a retraction of someone who saw that movie or read that book before they made those changes, that harm exists. And the harm here is substantial, because my client is a developer, and after that, all of his accounts got frozen, essentially shutting down his development business, which, by the way, is not in this country. So, in the end...
So your position would be, if I read a defamatory article in the Tampa Tribune, my standard reader is going to read the Tampa Tribune tomorrow and the next day, and is going to be aware of a retraction?
Well, the purpose of it is to afford that opportunity.
Okay.
If a retraction, whether it's read or not, is not the point. The point is can the retraction work if somebody does it? If a movie retracts something, nobody's going to watch the movie to see the retraction.
I was just focusing on your comment that people don't usually reread a book.
Yes.
But I guess you're presupposing that people are going to regularly read the Tampa Tribune.
Well, that's the basis. Well, I'm from Fort Lauderdale, so I assume people are going to read the Sun-Sentinel, but the retraction statute presumes that people are going to read the newspaper again and see the retractions, right? I mean, that's the purpose of it. And The final point I would make as it relates to retractions, the same goes true for internet blog posters, right? Putting aside the person who might post on someone's article or comment as an individual who I don't think would be covered by this statute under either party's interpretation or arguments, you have the internet folks who are posting. They are the hosts of these blog posts and these online magazines or newspapers. I think that the cases are consistent with the idea that those are news media. They're the press. As a matter of fact, in the case cited by the petitioners, the Comans case, Comans v. Van Voorhees, the court goes through and talks about how traditional newspapers and periodicals wrestle with the concept of how easy it is for blog posts to go to the internet so quickly and so easily, and it's almost like it's a competitive advantage for the internet posters versus traditional media. They don't have the same cost structure, they don't have the same practices and policies, and therefore they shouldn't get this protection, but they do get this protection because it is exactly what Ross said. It's the speedy dissemination of news and information through news and broadcasting. That's the concept. And therefore, we respectfully request that the court affirm the trial court's, deny the petition for writ of certiorari and allow the motion to dismiss to stand. Thank you.
Thank you, sir.
Your Honor, where to begin? First of all, with your hypothetical, it actually was a true case that I dealt with that begun in Florida federal court, where a writer for the New York Times, James Risen, wrote about a subject in the newspaper. There was no complaint. When he went to write a book that made the same allegations, he got sued here. There was a retraction demand before the book. Nobody thought it wouldn't require a retraction demand because it is content. That's, and as Ms. Steele said, the First Amendment protections. And the book had, of course, all the other First Amendment protections, actual malice, fair report, all the other things that you would apply. So it absolutely makes no sense to distinguish between, oh yes, the newspaper would get a retraction demand, but the book wouldn't. Mr. Pallenberg refers to, and basically admits, okay, going forward, they were able to make the paperback, not have the Baraya name, ebook, audiobook. What he's talking about is the 2009 book, which is not in suit, where the statute of limitations expired long ago, where they never made a complaint, and there would be no retracting a 2009 book that's not even in circulation anymore, and they didn't avail themselves of that remedy. And indeed, in this case, as of 2017, when we moved to dismiss, the plaintiff's counsel was on notice that we were making this argument. They chose not to dismiss this lawsuit and make a pre-action notice and then refile. Instead, they just went on the pre-publication notice from May of 2016, which didn't address the 2016 book, which is what is in suit. The 2009 book is not in suit. The 2015 audio book, which sold less than 450 copies, and was a verbatim reproduction of the 2009 book. As to that, we would argue that the notice that we got in May of 2016 did not meet the statutory requirement to specify the statements that are alleged to be false and defamatory. That is typically a verbatim quotes, and the fact that this is a book indeed allowed, the second amended complaint has 31 quotes from the 2016 edition that they claim are false and defamatory. They add no quotes in their May 2016 letter, none. That is hardly the best possible notice that the Nelson court said was required. That's hardly the particularity that's required. Indeed, even the topics that were covered did not include all the topics that he is now complaining about, including questions about his sexuality and his drinking. And in any event, it had no quotations. And if you look at, in the Schiller case, a recent case, what was the notice that was found to be adequate? 4 pages of quotes. That was what was deemed to be adequate notice meeting the statute. Here, that hasn't been met at all. And I believe that's all I have. If your honors have other questions, I'm happy to address them. I would say, as your honor has pointed out, other medium is intended to be a broad definition. No, I think the publishers would find it curious that they're not considered media defendants. I would include them in that term, but they surely are disseminating important information for the public, and that's what this statute is intended to protect.
Thank you very much.
Very interesting case. Thank you all. Well argued.
Two more minutes.
Do I have one?
Oh, do two? Oh, I'm so sorry.
Everyone gets their due process.
Thank you, Your Honor.
I'm sorry, Mr.
And I will take less than 1 minute. The argument that I'm hearing from the respondent is very much like, well, the newspaper's already out. What good is a retraction going to do? Because people may not read it tomorrow or the next day or the day after. With a motion picture, a major motion picture, sure, someone could go see it in the movie theater, but also we have to now, in current times, look at the life of a publication like that. DVDs, streaming, on demand, and all of the possibilities for people to continue to access that content where a correction or change would be effective. And also, we don't distribute them in those big silver canisters anymore. It's digital. Things that are digital can be recalled and changed. Just like if you buy an ebook, that ebook can be updated and you can download it again. So I would thank Judge Guzan for your question about in pari materia, because when you look at 770.05 and then on through the end of the chapter through 770.08, they are all talking about the types of media that Your Honor mentioned, including books and motion pictures.
But if you look at 77.02, the retraction, it just speaks of the newspaper or broadcast station.
That's true, it does, Your Honor. And I would suggest that's I can't, intuit what the legislature had in mind there, but this is a special protection offered to these particular publishers, that they can avoid punitive damages, and the plaintiff can recover only actual damages as long as there is a full and fair correction, apology, or retraction made within the time limits specified. So that doesn't mean that nobody else can make a retraction or correction or apology. This sets forth a special protection for these particular types of media, which I believe Ross versus Gore recognized are dealing on a moment-to-moment basis.
Thank you, Ms. Steele.
Thank you, Your Honor.
Thank you all. Very interesting.